The most controversial aspect of this SB 1070 was upheld. Much of it was thrown out. What did the majority say?
Yeah, there were a lot of ironies here. First of all, you have to understand that most of SB 1070 wasn't even taken up by the court. It's been in effect since July 2010, and it's there. And now the most controversial one, as you said, which is the provision that when police stop somebody lawfully and then they have probable cause to suspect that they're in the country illegally, they're required to verify their immigration status. The court threw out the government's argument of effectively preemption by executive whim. That is, just because of a resource allocation decision or a prosecutorial discretion type of decision, the federal government the Obama administration wanted to preempt the state law on that grounds. The court said no. This doesn't conflict with any federal law. They're just cooperating as the law intended, and Arizona can direct its officers to do this sort of thing. So that was upheld. The other three provisions that were at issue were struck down or found to be preempted. And there was some dissent on this. There was 5-3 on two of them and 6-2 on another one. So there's one provision about alien registration laws, federal law that aliens have to register in certain ways, and Arizona made that a crime to violate that federal registration law. The majority said that you can't do that. The federal government has set up the entire scheme. You can't add extra state penalties, even if there's no other elements that need to be proven other than violating the federal law. I think that one, I probably disagree with that one. That could go either way. Justice Alito agreed with that one, so that one was the 6-2. And then there was another one about fining employees or filing illegal aliens who sought employment or were independent contractors. I agree with that because Congress did set out a comprehensive scheme of employment regulation relating to aliens, only punishing the employers, not the employees. And finally, the provision about police being allowed without a warrant to arrest people they think have committed deportable offenses. So unlike the first provision that was upheld, they haven't already stopped them for speeding or drugs or whatever else. They're just think that they've committed something deportable. They see someone committing a murder, and I suppose in addition to arresting them for murder, they arrest them for a deportable offense. Court said no, the local cops aren't trained in that. That's only for federal officials, so we'll strike it down. But look, it's a very technical opinion. Rather than get lost in the legal weeds, what we really need to see here is that neither state action nor federal executive policymaking can reform the immigration system in this country. That sort of thing has to come from federal law, from Congress and the President getting together into some sort of grand compromise that will put together provisions that benefit both highly skilled and unskilled, a DREAM Act with a green card stapled onto everyone's doctorate, and all the rest of it. These sorts of piecemeal, stopgap approaches, whether by the President or the states, some of them are constitutional, some are not, but it really is nibbling around the edges of what the real issues are.
Several other states have similar laws patterned after Arizona. What happens now?
Well, as I said, only 4 of Arizona's laws ever reached the Supreme Court, so those that are patterned or mirror Arizona's law will accordingly be upheld or struck down. A lot of these cases have been held in abeyance pending the action of the Supreme Court. But there are a lot of laws in Georgia, South Carolina, Alabama that add stuff to what Arizona was doing, to the extent that they create new kind of regulations that are more of the immigration ilk than purely local crime or business regulation. I think they're on shaky legal ground. But to the extent that they followed Arizona and simply said that, look, there's no federal law directly in conflict, the federal government has not legislated in this area, you're free to do so. Those will be upheld. But this isn't the end of this sort of litigation, and it's certainly not the end of the discussion. Well, one thing that we know for sure is that immigration will certainly play a large role in the election campaign this summer and fall. And hopefully, under the next administration with the new Congress, we can have some sort of comprehensive reform.
Some people have cast this as largely a victory for the Obama administration.
It's a mixed bag. I mean, both sides are going to spin this as, Arizona's going to say, well, the most controversial, the most practically in effect one is the one that we got upheld, and the rest of it has already been in effect. And the U.S. government will say, as you said, that we won on 3 of 4. It's a mixed bag, and it shows that in this very technical area, whenever you're dealing with preemption, be it immigration or product liability. The court is going to go line by line, parsing the statutory text and really seeing whether there's a conflict there.